एक पैटर्न
Who is appearing for who is for the city? Madam. You have to see this part on next Monday. Yes. He's come ready. Susan.
First case. First item. Same heading.
One of both the matter.
Yes, before the mail on Monday.
Item one.
Item number was the position as.
State that item number one.
But this matter was hard and.
We will definitely do it when we have fixed this matter and part. We'll have a consultation. We'll do it.
Okay.
That is especially a fixed matter.
when is he going
Way back in April 2025. So we are virtually after 1 year, when you have come for extension.
Let's see,
1 year. What is your explanation for 1 year?
after the,
Maybe ailment is for 1 month, ailment is for 13 days, 14 days. 1 year.
see, he was,
It's a private limited company, you have lot of resources.
Both of you consider that there is a temporary, you have delegated to 5 days.
yes, yes,
And 3 weeks granted, 3 weeks, 2 weeks, whatever, 3 weeks, let us hope 3 weeks.
yes, yes.
Within that 3 weeks, have you come forward with the extension of time?
But since 1st of June, he was.
So you lost
my
my
business.
You missed it, bus. For
How many days you were there in the ailment? Just tell me, you were admitted, the date of admission is of 21st of August. And we granted you a 3 weeks time, that was in April. What you were doing in May, June, July,
Let's see, he was on
and
treatment,
practically 3/4 of the August.
he was on treatment, let's see.
No,
because of
no,
cervical
no.
myopathy.
Uh,
Let's see,
Date of
actually,
admission is 21/8. The discharge date is
that was in 2024, let's say, he was, he underwent,
26/8. What more?
he underwent the, operational, let's say, that cervical removal and implantation, let's say. After that,
I understand that previous to that, what you were doing, there is nothing, only one certificate you have been given
No, let's see, that is
No.
4/6/2025, one certificate I have given, and that document is also, that is at phase 8, let's see.
No, I have seen, that is the 4/6.
Yes, let's see.
So what you were doing?
He was under treatment, let's see,
No.
after partial recovery, let's see, he has already
And
deposited
when
the.
this matter was taken up in April, you have given a certificate at page 9 of January.
Yes,
When
let's
you
see.
have, you were suffering, you could
Yes,
not
yes.
have.
No, let's see, that was the medical, the prescription, let's see.
Is it? This is the only director. No other person.
1 month, neither and neither, there is no difficulty, one can understand. 1 year.
Since September, he has deposited the pre-deposit amount, let's see. Already,
That's a, it will be an injustice. There is a limitation period for a claim.
let's see, has been.
So 1 year. The court will condone. We are very compassionate. We are very sympathetic, but there should be something. If you merely on an application, a drop of the application, the court should not go and.
But then let's see, he was under treatment, let's see.
The greatest injustice will be to reach. It is the greatest thing. No, God. If the private limited company, if they are running a company, then the company run by me. If not a single director.
Also, it's very much declare on nobody. It's depends what that is. You can also. Another director can also be. Filing one point. Let's see.
Yes, sir, already pre-deposit amount has been paid, let's see. Since September 8, 9, 2025, pre-deposit amount has been paid. Only to file appeal, let's see.
This was 4 weeks.
No, let's see, he was under treatment, let's see.
Then June,
Because-
July, what happened?
Let's say he was under treatment, because
And was not traveling. He or she could have immediately stopped somebody to take care of. May not be personally or physically possible. This is a private limited company, it's not an individual.
Was the business stop?
since
Business or you were trying with us.
in September, let's see.
Ongoing contract, your name suggests that you are a construction company. The ongoing projects must have been there with you. You were continuing with that ongoing project. Now,
also 4 months delay, let's say, time, let's say.
what?
4 months delay, let's say.
How much?
4 months.
4 months delay. I don't believe you.
Let's say, in the 30th April, let's say, has been pleased to pass the order.
For how many days?
So let's say 3 weeks, let's say.
So, 3 weeks expires when in the month of May.
May 22nd, let's say.
So,
In September 8th, I have deposited the deposit amount.
that is not a thing. That is not a thing. You are seeking extension of time to.
8, 9, 25 lakhs, I have deposited the deposit amount. 8, 9 lakhs. At place, share was executed.
You started finding that after lapse of extension.
Statutory period is 3 months, let's say. Statutory period. Months, let's say. Service of data service of business.
I am so after 3 months from so just because of difference from some
So I can suggest something in other labs.
We accepted your contention that you have not been served. We granted you that like a particular leverage. That does not mean it has to be so casually
It is, madam, it is.
Sorry, let's it's not.
When the application is happened, 7 months, 2024.
And it is
21, it was served on one version. You accepted that. Thereafter 1 year.
no, let's see. The order was for 24 and it was served in March 25, let's see, as per the page 61.
Yes,
Without
Recovery proceeding, let's see.
without going into the veracity, they were contending it is, you were contending it is not. We accepted your version.
Yeah, let's see, my learned friend accepted and
That
officer
is
also
what
accepted.
lastly he accepted that.
No, let's see, he has also, the officer has also
And I
accepted.
understand when he accepted that it has been done in March, we granted you a liberty to go and file.
20th,
What more than what he will do if you
no, let's see.
sleep in those manner, what more?
No, let's see.
If you are within time, don't seek for extension. Why you are coming for extension?
Because of your lordship's order, let's see.
No, not your right of appeal, if it is there, you could have filed it. If they say something, you could have come and say that I am within time. No.
Because 13th April, your lordship
Sorry,
has been
please
placed in
make
pass
that.
order. And I have deposited in 8th of September, let's see.
If it is a 3 month, then it must have been in June. She could have come within June. Why she accepted for 3 weeks? You have recorded in paragraph 6. Decision which was made by him. You came in September, July.
Came in May, your lordship.
No, July, you
Order
came.
was passed in July, yes. I
Then
came in May.
then this court did not. Then what you were doing for such a long period?
Since 1st June, your lordship, he was in treatment, your lordship.
No.
Yes, he was on treatment of cervical myelopathy, your lordship. Kindly, your lordship.
There is no denial from your record, but your conduct does not really instill confidence that you can. Sorry. This is an application seeking extension of time to prepare an appeal.
34,075 current 2 weeks time. Just dictated or
Para 6 requests, please.
Oh, I have seen 3 weeks, 2 weeks, I have seen. Paragraph 6 and 7, so I have not got.
Some people that I am praying for a short adjournment. By tomorrow, we'll file your objection and application by tomorrow. That's my time.
This cannot be, on your assurance, this matter was, it was fixed. And we always trust and hope that when the responsible counsel submits something, then he always take it as surplus. But this cannot be used in this way. The short adjournment and
But in the meantime, we could not sell some ingredient.
Well, let the state file whenever they want to file it. I don't know, kindly go ahead with my application, which is standing independent to that. Nothing to do with the application of the state.
We are filing objection to that application.
what objection?
We have objection.
What objection?
By tomorrow, we'll file for advance copy.
You, on the other day, you said that you are filing an independent application for some modification of an order. So we just thought that, yes, if the modification application is coming out, then we will dispose of both the applications at one go. If we modify the order, then naturally whatever is there is to be taken care of. But it appears that you are not coming up with the modification, but you are coming with the objection to the instant application. You would have said that you want to file an objection to this application on the last occasion.
My lord,
I could not see something on that time. I received their application late. That's why we are filing an objection and our application by tomorrow. Today I will serve advance copy to them.
my lord, I cannot file anything in the registry without serving them advance copy. They have been receiving advance copy. On that day when they appeared, they were already in possession of the advance copy. I have the proof that we have solved. My lord, I am not getting into it. My lord, I may be allowed to make my submission, sir, with regard to the application. My lord, it's
I have seen that.
Yes,
I have
yes.
seen you just simply wanted about we have directed, whatever the directions are there is there.
yes.
There we will just looking at. Your prayer is that sometimes if the timeline is not given, the government may sit over it for some discriminate or indefinite period. They will not be able to activate the directions they need. I understand, but sometimes then portion of enforceability, portion of due implementation will be a problem.
Right.
I understand. So to that there is no difficulty. So far as the other portion is concerned, that portion you wanted a highlight something, which does not, none of the provisions speaks about this concept. What we can say that the spirit of the order, what we have was that whenever there is, and if the government thinks that where it is absurdly low,
Yes, yes.
there is no difficulty
My lord.
to activate, they identify.
So therefore, we have So this 50% obviously it is not coming from the statute, but we said, let us indicate something.
Why should we put something which is not
How come that, my lord?
the statute?
The whole idea that somebody.
Understand. So they should not sit in a slum or
Yes.
sit in a slumber.
Yes.
That is what you really wanted.
My
So
lord.
we can
Just period we clarified, my lord. We don't have any this.
clarify anyhow. So,
If because my lord, just one sentence. That para 13, your lordships are very rightly the directions and everything which have come. This clarification, even without reference to a let's say 50%, like your lordships have just followed
that is
the
that
Abbotsford
conveys a very
Yes.
laudable one.
Yes, yes. My lord,
That is very clear.
para 13, my lord, may I read?
Yes, I have.
Yes.
We are reading. We are. This is something which is very innocuous. We ought to have fixed the time.
I don't think we have specified everything beyond the statutory prescription. We have said you should adhere to the statutory. That's all.
But I only pray that it will be taken up next week.
This fact.
Not unnecessary. Yeah, by judgment,
Item 3 disposed of. Item 4.
We have some refresher argument.
Yes.
Not extensive.
No, not extensive. I'll keep that in mind. The tender was floated in the month of May 2025.
You do not have to give the dates, you will get it. When that was floated, what is your concern?
My concern is that first, tender was rejected by the same letter.
This is now that they have rejected it at one go. That technical bid states that you did not qualify, and then they revoked the entire
Tender?
tender, and then they proceeded with the financial bid, and then
There's a
awarded.
glitch in between.
Now they say that this revocation is only at the technical bid stage and nothing more than that. Beyond that, they do not say anything about it.
And Annex 11 at page 80 is
I
an
wanted to highlight cite two judgments, revocation, what revocation would mean,
Yes.
that is there. What revocation would mean.
Just
And
one
then what we
judgment,
are given.
just one judgment your lordship had read in details. The other judgment is also of the Honorable Apex Court. May I point out what they have said about this word revocation insofar as even Parliament is concerned? Their lordships have said even Parliament cannot give it a different meaning altogether.
No, I understand. Keep it to one, send it to me, I will dictate it. Now I understand.
Grateful.
Item 5.
You got sets of this judgment, Mr. Counsel? Have you tried two sets of judgment or one set of judgment?
Two sets of options.
Two sets.
We have already submitted two sets.
34. A second computer.
For both, two sets for honorable judgments. Forgive me.
You,
We have given 4 judgments.
okay.
In that occasion, my learned senior had committed that by 31st March, he will vacate.
Yes.
And your lordship has observed that he must file undertaking affidavit to that effect. But it has not been solved on me, probably it has not been filed. And second thing, my lord, since I am unable to answer your question because of my hearing impairment, the present petitioner number 2 son, who is their authorized representative and registered general power of attorney, is with me. He will assist me and he will reply your questions. I beg your leave. Lordship's leave.
What will you?
Whatever question will, I am not able to hear. I can submit.
You have
He can answer the question.
You have your friends there, you
Yes.
have your assistant there or not?
Sir, I am the petitioner.
In case the lawyer must say, ask him that he is, you are assisting him.
No.
Are you assisting or?
No, ma'am. Under connected case thing.
Connected matter, yes.
You are for the opposite party.
I am the petitioner in the second case, number. It's single bench matter, number.
It's a different matter.
I am the agent of the HPCL, number.
Oh,
I am running the petrol.
oh, you are having a conflicting interest.
But I can
With
say
the-
what your lordship, I
No, you
can,
are, anyhow.
I can convey what your lordship says.
On 3rd February, your lordship has already been heard this matter. Only your lordship directed that affidavit should be filed or undertaking should be filed.
You wanted us to extend the time till 31st March, which we are not.
No, 31st March is the last.
We have to file.
For 31st May, but after taking instructions, we will vacate the place by 31st March.
When is the undertaking?
That undertaken will file within 2-3 days. I have already. Your lordship may record it. If
No, we once recorded and he.
Then you will be held liable. Are you ready to take a risk?
your lordship may.
You are giving an
Wait.
undertaking to the court on behalf of your client. So we will record. Are you advocate and record?
Yes.
Will record. If he violates, then you personally will also be responsible. Remember, when you take such a great risk, then you should know.
By Monday, I will file the undertaking. No,
It's not a charity, sir.
no, I have
You are
already.
occupying a property of a
I
third party.
have already the person concerned who signed the undertaking. But because of his illness, I could not.
You have any issues that whether he is a person who is entitled or he is a person who is not entitled? When you raise an issue on his status, we are appointing a special officer, Mr. Tripathi, who will take possession immediately and keep it with him. And then you fight whether he is entitled or he is not entitled. Possession must go.
31st March.
Let it go. First thing is then you fight on the title. Possession given.
By 31st March, we will give it the permission.
And you'll have to pay a compensation and lump sum. You have to pay. A lump sum compensation. No. It's not so easy, sir.
By Friday, I will file the undertaking note that we will file it, vacate it by 31st March.
And also an undertaking to pay.
Already this honorable court has directed to pay 20,000 per month. That we have
That
already.
was interim.
Or
Yes, Mr. Das,
senior counsel already approved. And we wanted that amount to be enhanced.
consider that
Lockdown thing. Where is the property? Where is the property?
At Sambalpur, Antapalli, Antapalli, Shokot.
Is a fully populated area?
Earlier it was outskirts, now it's a heart of the city, Maluma. Now it has got prominence.
Is it a prime language? Prime, what is the market lending rate?
By the undertaking by 31st March, we will better the measure.
They have nothing to say.
I'm in the other matter, where I am running the petrol pump, my HSD license was cancelled. I am before your lordship.
Nobody was there.
Without the HSD license, I have nothing to say in that case, Lord. The other case.
The light goes there,
I go. I automatically go. That's why it was tagged with this case.
You go.
I imagine just submit.
They have cancelled.
My learner friend is
State had cancelled.
the dealer who is the opposite party number 4 in my case. In this case, he has been served notice much I mean long back, but he has to do not to file a counter.
It's a dispute between the lesser and the lesser.
Please understand.
It's a dispute between the lesser and the lesser.
His case is not against you or against the order. His case is against the company who has terminated his dealership.
I have filed on my application, Miller. I have filed the application because the land was a disputed land. So they are dealing with the inflammable products. So if something happens, Miller, who will be held responsible? So considering all these facts, Miller, his license has been
Did not have to. If it is a disputed land, better to sit tight. Do not poke nose into it. It is a company who is running, who has appointed a dealer. If something casualty happens, it's a company and a dealer who is responsible. Why the owner? Owner has no role to play.
No, on his complaint, my license was cancelled. State had cancelled it, and I am challenging the action of the state before the lordship.
And the company was also a party there, Miller. HPCL is also there a party.
And pay 10 lakh rupees as compensation on 10.
I do not.
There is no
Yes, with connected matter and appearing matter. My name you agree with this. Mr. Das name is inadvertently
You are the appellant or the
We are respondents.
respondent? So you are challenging which order? They are challenging which order?
My lord, the order dated 11/8/2017 passed by the Honorable Single Judge in execution petition number
11/8.
11/8/2017.
You are challenging them.
My lord,
And you are not challenging this order.
We are challenging that order in Supreme Court.
Which one?
On this 11/8/2017 order.
Then what happened?
My lord, Supreme Court on 3/4/2025 disposed that SLP with a direction 3/4/2025. That order was
3/4.
3/4/2025.
Where do I get this? Yes, T4.
But the interim order was passed on 11/8/2017 by the Honorable Senior. How we prefer the appeal file 25.
Yes, yes, sir. Once we have suffered an order without raising any issue, then can you now fall back and say all these things? Then how can they go? The apex court has entertained on merit. So the court in paragraph 6 has summarized it of the order.
Okay.
In paragraph 6 says that we can say that the single bench cannot interfere with the award. And equally you have gone to appeal, you can challenge that order as well. So both have to be decided on that basis. So now we have heard, and you have filed your written submission.
No, minute, I am not fine. I have argued only Corara.
What is the sum and substance of your challenge to that order?
My lord, my servant substance is that the report of the commission, Lord and arbitrator. The report of the Lord and arbitrator is under challenge.
Report of an arbitrator was a subject matter before the executing court.
Yes, madam.
Executing court interfered and reduced it from 14 crore to 7 crores.
Yes, madam. But without any basis, madam. Without any basis.
That is according to you, the single bench, how he has arrived at
We
7.
do not know, madam, how he has arrived at a conclusion.
Now, when the appeal is here, the question is that whether the single bench was competent enough to interfere with the award or not. Now, suppose this order goes of a single bench. That does not mean that the award will also go. It is only a reduction from 14 to 7 is found to be faulty. Correct?
But
There was no basis. Now the Supreme Court has really opened the entire issue before the division bench. Now, once it is opened the entire thing before the division bench, then you'll have to say why award is wrong.
you have raised that valuation is, my lord, 40 lakhs per acre.
But the arbitrator did not agree.
The report of the arbitrator is accepted.
So what is the basis of arriving at 14 crores by the arbitration?
So motor he has assessed.
How?
Where
is the
he has gone to the spot.
Where
He has assessed.
Where is the award?
Award is made of. Page 64, annexure 4. Page 64, annexure 4.
It's 64, I do not get it. 64 is something else.
Annexure 5. Annexure 5, my lord.
This is the report. 66. Yes.
Learned arbitrator has not examined any expert panel. And he has not cannot try to obtain the report from the district valuation committee. And the entire 6 acre, 677 decibel was taken into consideration. Instead of 1 acre,
Just
837, madam. Paragraph 10 is important.
yes.
Yes.
Paragraph 10, your lordship kindly.
No, I have seen the whole.
Paragraph 10 and 10. The
Whole of it, even 11.7.
10 and 10.1 is important, my lord. May I read, my lord? The main bone of contention between the
No,
parties.
I have seen, I have already read up to 11.7, sir.
My lord, the Lorraine arbitrator has taken into consideration the entire 6x or 676 decibel instead of one of the 37.
That is true. He interpreted the order passed by the Supreme Court, appointing him as an arbitrator. And that is correct because he has reflected that.
But we have objected, my lord, we have stated, the DA department
Can you
stated
object
that.
to Supreme Court judgment?
No, Supreme Court, not Supreme Court judgment, my lord, at all, my
If
lord.
he has said that the Supreme Court has directed him to consider this.
But the suit property is 1 acre, 837 decibel, my lord.
Because it was a 9 acre and something, the whole of the property, out of which you have taken 15% of the land, which comes to 1 point something.
Total 6 acre something.
The
6
Supreme
acre.
Court has said that we'll have to consider it, that what should be the value, and then carved out. That's all.
The entire, my lord, that is the Sar of the land and it consists of roads, drains, water channels.
That is what was.
And but the surrounding land is high value.
Actually,
Surrounding land is high value, my lord.
true, that is why the.
That's why he has submitted the report, my lord. Entire, taking the entire.
I have seen it. I have seen. And in 1992, when this happened, there was no drain.
This period.
He has come to the conclusion. There is no drain.
The lordship, the J department has valuation, benchmark valuation is 40 lakhs, my lord. 40 lakhs.
No, sir. Your evidence was there, your cross-examination, everything has been considered by the court.
As because the London arbitrator has gone to the spot and found some building.
Because he has given.
There is no necessity of going there, my lord. The London arbitrator could not have gone to the spot.
There was already an order passed in second page of the report. That what is the topography of the land? It is said that in order to ascertain the market value of the market value prevailing as of the date of the property, Vizaya, Mauta number such and such, unit number such and such, tehsil number such and such, district, Thana, Khata number, name of the owner, plot number, area is 6.676 decibel.
That is not correct, my lord. 6.6,
Go there.
that is not correct.
Go there, go there.
Yes, I have seen that. But the disputed land is 1 acre 37, my lord. That is to be reported, my lord. If
I
the
am again saying, you are a lawyer. Can a high court go beyond the order of the Supreme
No,
Court?
never.
Or can
I never.
go and say that this portion
Never,
of the
never,
order
never.
is
I-
all factually incorrect?
No.
Can the high court do that?
no,
But
never, sir.
so
One area is also defined in the Supreme Court order, saying that what area the valuation has to be considered, then nobody can go beyond it. This is what the arbitrator has also said, that he has quoted that.
My lord, that's why it has remanded to my lords to
No.
for adjudication
No,
by the division bench, my lord.
no, only
They
thing
could have
is,
decided, they could have decided, my lord.
sir, only thing is the reverting back to the High Court only to ascertain the market value. It does not talk about the area of the land. It simply says that whether the market value determined by the arbitrator is correct or not. We will go by the market value. It should be 14 crore, it will be 10 crore, it will be 12 crore. They are claiming 25 to 30 crores. And the single bench has said 7 crore. We have to just concentrate on that. We cannot go on the measurement or the area of the plot. Was the Supreme Court on concession? On concession. It is said that after hearing, that is a Supreme Court judgment, after hearing and with the consent of both parties, we pass the following order. Then the description of the property at the last, plot number 353, Kisam Sara 2, area AC 6.676 decimal. This is there in the order of the Supreme Court. What more? This is what What more? How can you say 1 point something? Go before you order, ask for a clarification. Before the Supreme Court.
Yes.
Straight away. We can't.
We'll go to.
At this stage, at this stage.
Yes.
You will go.
We leave it.
The order was passed as far back as 9/2013. We are on 10th of February 2025.
Yes, ma'am.
How many years? What are you, sir? You're a senior counsel, you know. And I'm told by my brother that you have a civil flavor in your mind. You have a civil flavor in your mind.
Yes, I know.
Can you tell me, can you, even 151 can be invoked to that extent? Now I'm talking purely on a civil law. Can it be? What are you talking about? You have suffered, and this is a consensus order. So, the civil law is very clear. If an order on consent is passed, that order can only be recalled on consent, not unilateral. You know these basic civil principles. How can you recall it? Unilateral.
Their appeal also itself is not maintained because your lordship may see
the last order of the Supreme Court says that since they have already gone in an appeal, they are entitled, in paragraph 6 says entitled to contend that the market value is not correct. Equally, you are also entitled to say that the judgment of the single bench is not correct. So, and once you have gone for an execution of an award, that shows that you have accepted the market value as determined by the arbitrator. You cannot now say that this market value is low.
No, I can.
You have gone for execution. So you can't now. You can only defend. You can only defend. That's all.
This order was a single judge on the person of their state council that we are ready to pay 7 crore per acre, and they are again challenging their own order here by in appeal. That ridiculous. Now the Honorable Supreme Court has directed that
we have stated
we
that
should contain that in execution.
Market value is 40 lakhs per acre.
He is raising, once you have consented, can you wriggle out of the consent? Whether an appeal lies on consent.
Last occasion, I also have information.
I'm talking about, then I'm talking you go through section 96, subsection 3. Decree passed on consent, no appeal lies. Does it lie? It is not an appeal under 96. I am conscious.
No.
It is under the latest patent. The appeal lies. But still, when you talk about the principles, then how it lies? Anyhow, yes.
Chapter 45. Under order 45 rule for 16. This exhibition of it has been filed.
Order?
Order 45, madam. 45, rule 16.
16 what? What order 45?
Supreme Court's order.
Civil procedure.
No, that is a Supreme Court. Oh, give me.
No,
When you talk about order 45.
Supreme Court adjourns to this honorable court, my lord.
Oh.
The order of the single judge. Your
It
lordship
is.
can see.
Please.
Yes.
Order 45.
Rule 16, your lordship can see.
Yes.
Rule 15.
This appeal is maintainable.
I understand.
It is.
Civil. Criminal. Civil. Say it. See, record. Okay.
This is again, I'm saying, this. I was also surprised with this. Because the order 45, when you are taking a shelter there under, what it says that it is the order of the Supreme Court to be implemented or executed. It says that it will go to the court from which the SLP or appeal arises to the Supreme Court. That court will be the executing court for that purpose, or in the event the Supreme Court has mentioned that where it should be implemented, then in that court. Because the spirit of the Code of Procedure is that it is a decree passed by the court of first instance, even if up to the Supreme Court, it is a court of first instance who is the executing court. You are aware?
Yeah.
So it goes to the court of first instance for execution. But this is something, a departure that has come. But this is in relation to a decree for the first time the court passes or an order and wanted the implementation, not under the mandamus appeal.
That is the order.
Order means in a civil proceeding.
Yes, civil proceeding is order.
Is it a civil proceeding?
Civil proceeding.
It is a civil proceeding.
Fine.
What are you talking about?
There is specific direction of the Honorable Supreme Court, and in execution, they cannot go beyond the decree first.
That is
So they cannot now go beyond this decree.
That is a too settled a proposition of law that nobody can go behind the decree or beyond the decree. Executing court can not go.
That is.
Yes, let me consider. Yes. Because the many facts are involved, so I have to jot down the facts. So just, I'm keeping this matter for the next week, but in the meantime, I will go through it.
Next week, my for orders.
Yes.
My lord.
No, latter part, just give.
24th February. Item 7.
Additional affidavit for bringing on record the reflections which were filed in time, on time. That must be just to come. Yesterday I filed the additional affidavit.
Item 7. Additional affidavit.
Yesterday I filed additional affidavit. Have you given a copy to me? Yes.
No, the copy has not been given to us.
Yes, already given.
Where show us the service?
Is that in this case, the answering opposite party is the state? In the office, maybe in the office, maybe then Millard.
So there should be a.
Yes, Millard. Then Millard, today it is not there, but if he has filed, it will be
That the receipt is here with me. I have given yesterday.
Yes.
Yes. His office should not have given
Yes.
yesterday your time.
Yes, sir.
How do I read these documents?
So I'll try to English translate because earlier the client came, they were written while the translated copy, I will bring it on record with them. On 21st, one time to file the translated copy.
Additional affidavit is filed by the government.
Trust copy रे पूरे होगा ना Adjourned to 24th February. Item 8.
Your Lordship, item 8, I appear in person, Your Lordship. Your Lordship, this is a very short matter, but before starting with the PIL, Your Lordship, I would like to brief the court about the factual background of the case, Your Lordship. In the year,
Who is for the state?
Union of India. This is again the Union of India, as per the.
Yes, sir, my lord, I am.
Oh, you are appearing.
Your Lordship, it is about a PIL was filed in the year 2024, Your Lordship, with regard to the repair and reconstruction of the 17-kilometer Ghat road, which is in the which is known as Dwarsuni Ghati in NH 49, Your Lordship. And then Your Lordship may kindly come to page 22, Your Lordship. Kindly come to page 22.
Yes.
Your Lordship are in page 22.
Yes.
Mr. Srivastava, learned advocate, virtually appears on behalf of the petitioner and submits prayer of his client is for widening of NH 49 on 17-kilometer stretch at Dwarsini Ghat.
Yes.
Mr. Raiguru, learned advocate, senior panel counsel, appear on behalf of Union of India. None appears on behalf of NHI in spite of track consignment showing delivery of notice on 16 December 2024. List on March 2025, it is made clear the writ petition will be dealt with irrespective of appearance on behalf of NHI, Your Lordship.
Yes.
Now, Your Lordship, this PIL, the present PIL is about the toll collection at NH 49, Your Lordship, which is known as Jharpokaria toll collection, toll plaza, Your Lordship. Now, Your Lordship, they are continually and unlawfully collecting the toll, despite admitting the fact that the repair and reconstruction will be ended in the year November 2027, Your Lordship. Your Lordship, I have made a representation. Your Lordship may kindly come to page 34 and 34 to 37, Your Lordship. A representation was made, Your Lordship, about suspension of toll collection, Your Lordship, citing the Kerala High Court judgment and the Supreme Court recent judgment of Supreme Court, Your Lordship. And then they replied, Your Lordship may kindly come to page 39, the reply.
Yes.
They say the scheduled completion date in the box, Your Lordship, para 8 of the box.
Yes.
They said that it will be completed in the year 2027. That is, the date is 22nd of November 2027, Your Lordship.
Yes.
And in para 10, they says there is 2 numbers of toll plaza falling within the project highway of Baharagoda Singhda section of NH 49, and toll plaza at near Begunia village will remaining closed due to incomplete section. The user fee is being collected only at Jharpokaria toll plaza at kilometer such and such for the completed section of the project highway, and incidence length of the toll plaza is considered within the completed section.
So they have said that they are not collecting it.
They are collecting a lot.
How can it? So then they have to come with the.
They may come, Your Lordship, and there is a Supreme Court judgment, Your Lordship, which I have annexed also. Your Lordship may kindly come to page
Sir, what they have said is that so far as the unconstructed or under constructed portion of the toll plaza, because there are two toll plazas.
Yes, Your Lordship.
So which covers this particular area, they are
Yes,
not
Your Lordship.
collecting a toll for that.
They are
They are
collecting.
collecting a toll of a completed section.
They are collecting for in a
How do you know? Their stand is they are not
Your Lordship,
collecting.
I myself being an advocate, I am the commuter, Your Lordship.
I do not know Mr. DSG when he himself is the witness. So probably he should not appear when he himself is a witness to a proceeding.
Yes, madam.
But anyhow, he is bold enough to say that I am a commuter, I know. What is your stand?
My lord, it is listed for first time. It is under construction. Basically, the Supreme Court judgment I have gone through. It should not be collected. Still, then I have taken instruction whether it's covered or not. So let him give some time in the meanwhile.
What your reply is indicative that you are not collecting. That is the stand of the authorities. They are saying that you are still collecting. Now, how to resolve this?
Your
I
Lordship,
think few days time. Let him give the 10 days
What
time.
few days time?
Because it is listed past time. I didn't have any instruction. But
No.
only.
Your Lordship, meanwhile, there may be a suspension in toll collection.
Generally, the toll collection has been made by the national authority. Ultimately, the Ministry of Road Transport is the authority who is monitoring everything. So both the organizations is separate. I'll take instruction from the NH.
Sir, what are you talking? You are DSG, you represent the entire Union of India. It is irrespective of which department or what department.
But they have a separate panel of councils.
So you are a DSG. How can you say that this is a separate department? You are responsible.
I'll take instruction for both of them. Only Lordship gives some time.
Had it been a central government council, I understand that we are only trusted to do these matters
Yes,
as a council for the central government. But you are a DSG.
Yes, I'll take instruction. Lordship give only 10 days time in that.
Your Lordship, meanwhile, there may be a suspension, Your Lordship, in toll collection till the next.
What? Merely on your ipsit dixit will we go by that? When they have said that they are not collecting, you say that you are collecting, that they are collecting. So how to ascertain that whether they are collecting or not collecting is a rival stand. What to do? Tell me, who is truthful? If we say that you are truthful, that means we are presuming that presuming or disbelieving their statement. If we accept their statement, then we are disbelieving you. How to go? Both of them.
Your Lordship, then they may come with an affidavit, Your Lordship. I leave it up to Your Lordship.
That's why in page 40 it is specifically stated in para 10.
That is what I read, that you have said that you are not collecting the toll plaza for an unfinished portion. You are collecting only for a completed section.
Yes.
No difficulty. We understood.
I'll take prepared instruction. If my learned friend is personally affected for the same, I definitely will take.
No, I'm not personally. Every people of Mayurbhanj district are affected, Your Lordship.
Yes, it is a public cause. Definitely.
And Lordship, I am sitting in Calcutta. I am an advocate of Calcutta. My hometown is in Rairangpur, which is in the district of Mayurbhanj. I cross NH49 every now and then, Your Lordship. That is why I prize of the fact, Your Lordship.
It's fine. We'll take instruction.
And Your Lordship, the writ petition number 29294 is already pending, and notice has been issued to NH for filing of their reply with regard to the repair and reconstruction of the same ghat, Dwarsuni Ghat, Your Lordship. And no reply has been filed till date.
next week to take instruction with PSG.
I'm grateful, Your Lordship.
17th February.
Grateful, Your Lordship.
Item 9.
My lord, this is about Odisha State Higher Education Council. It's a statutory body. I'm giving the statute. The vice chairperson term completed in August 2024. There are 15 members. Now there are only 2 members. 13 members have completed their term, but they are not filling up the vacancies, my lord.
Yes.
Pardon to mention only one matter. 29, maybe taken up 2 weeks after my I'll find a reminder. Some documents are awaited.
Not for me to get you because
Only I request 2 weeks.
you will find it. Then it is taken up.
Some documents are awaited, documents are not there.
Then you just request us where the matter is called.
Yes, grateful.
If it is not called, there you never. Yes.
In fact, the decision get
A date was fixed for eviction, but Milord's an interim order was passed by this honorable court not to take any coercive action in another writ petition filed by the encroachers, Milord. So, Milord, we cannot proceed. However, Milord, on the last occasion, my lords had been pleased to direct Milord to obtain instruction whether the encroachers can be rehabilitated.
In fact, it's like this. We are the persons, very, very poor people holding some shops, shop, book shop. These are very.
Does the law?
No, I don't. I am not on that. Lord, I am not on that. I am not at all on that. Lord, I am specifically on our rights as contained on section 8(1) of the OPLE Act. Lord, we are in occupation. Lord, but we are in occupation for more than 30 years. 8A protects our right. 8A says. So that's the reason. That's the reason. Without considering our case, since eviction notices were issued, we challenge that before.
Simply an eviction notice inviting you to place your case.
So we are raising that issue before the single judge.
No. Why notice this stay? I think the notice is that why you should not be evicted.
After that, Milord, eviction notice was also issued.
So
let me tell you, Lord.
The opportunity was given. Everything.
No, Lord, they cannot give us notice. They will have to refer the matter to the sub-collector. That's the point. 8A is a peculiar provision which speaks about our rights of occupation for more than 30 years. And in that case, they will thus.
Relating to service matter.
Yes, Milord.
You have shown one judgment of the Supreme Court.
Yes, Milord. And one judgment from the Supreme Court.
Yes. Yes, Madam who is appearing on virtual mode in person, what do you have to say?
Sir, much obliged, sir. The Honorable Court may permit petitioner to amend the petition to remove all service-related averments.
Then nothing remains in the instant writ petition. If all those are removed, we have gone through it, everything is hovering around or centered around this.
Sir, these are the reasons, sir, RTI commission penalties and fake fabricated letters.
No, sir. No, madam. Everything is there if you say that we can't segregate in this way.
Sir, concerning corruption, misappropriation, sir, according to the SC,
if you want to argue, then we will argue on that particular proposition of law. No difficulty. We are bound by the judgment of the Supreme Court. And we will say that what this PIL is about.
Exactly in Gurpal Singh versus State of Punjab, SSC maintainability of PIL depends on the nature of public injury and not on the And again, Center for Public Interest Litigation versus.
Whatever I understand, but when there is a direct judgment that anything which concerns the service, then in that event, the PIL is not maintainable is a very clear judgment of the Supreme Court. And your entire petition hovers around the service matter.
In the petition, there is no personal relief or personal compensation.
No, it is not a personal relief or something of that kind.
It is about the policy. The policy.
Then the PIL does not lie because the court cannot direct the government to frame a policy. There is another judgment of the Supreme Court which says the courts cannot.
Sir, another judgment is Center for Public Interest Litigation versus Union of India. Here is misuse of public funds can be a reason.
No, that is a different issue when there is a allegation, but the public interest litigation is something different.
Sir, according to the judgment, misuse of public funds can be a reason of maintainability of PIL.
I understand, madam, what you say, but it is there with relation to the service, what to do, what not to do, contractual employees, whether to be accepted, not to be accepted, everything, you cannot do it.
Sir, another judgment is in Center for Public Interest.
You just give a judgment, madam, since you are appearing in a virtual mode, please give those judgments. You are referring, we will definitely take care of those judgments and will pass the order if you want, whether maintainability point is to be decided. You give those references of the judgment. Give on a chat box. Give those judgments on a chat box, madam.
Sir,
we'll consider.
Sir, now for the time being, the total, the detailed judgment is not at me. So kindly, sir, please give an date. So I could.
Madam, please give a reference. There is a system where the full text of the judgment will come out. Don't worry about it. You have to give this reference.
Reference, sir, Center for Public Interest Litigation versus.
Just take down. Take down and.
Center for Public Interest Litigation versus Union of India 2G case. And another is in Center for Public Interest Litigation versus Union of India 2012 3 SCC 1. The Supreme Court. Again, sir.
2012 volume 3 SCC page 1. Yes, we'll consider.
Sir, another one is Binit Narayan versus Union of India court duty to ensure accountability in corruption matters.
True, no doubt about it. No doubt. Write down, we'll consider that judgment.
It can be a reason for PIL maintainability.
No difficulty, madam. What you are saying, those propositions, but here is a different scenario. That is what I'm talking about. Anyhow, we'll consider. Is unnecessarily, we can't prolong the hearing. We'll consider it. Those judgments.
1998, 1 SCC 226.
1998, volume 1, SCC page?
SCC 226.
226.
This type of writing, I think.
Anyhow, no difficulty.
Another, sir, is Gurpal Singh versus State of Punjab 2005.
Yes.
5 SCC 136.
2005?
5 SCC 136.
136. Yes.
So these all judgments are based on maintainability of PIL.
Anyhow, no difficulty. We will consider it. Don't worry about it. We'll consider this. Yes. Keep it for orders on the maintainability. Yes.
Sir, thank you so much.
2 weeks.
24th February.
Okay.
Item 13.
May it please your lordships. The matter is such, it is regarding the construction of RI office in the Nayagarh Tehsil, RI office come residence in the Notar village of this Nayagarh Tehsil. On the previous occasion, the state was taken time for instruction, for getting the instruction why it's not being constructed, because for the past 5 years, this matter is lingering And as per Annexure 1, there is a government notification in the year 2021 regarding the construction. And after that, in the year 23 and 25, 2 tenders were offered, but till now, nothing has started yet. Although an illegal construction or unauthorized construction has started in a different village. Without
Unauthorized construction.
there is no notification, nothing, and it is far away from the village which has been mentioned in the notification.
Let I have given the instruction.
Instruction. What is this? Why don't you put it on affidavit?
Let the construction, I will file it.
What? I will file an affidavit.
Construction work already started. And
in this village?
No, Millard, in another place. Because in the particular place, Millard, no legible land was available. There was a committee, Millard, committee reported that it may be constructed in another village, Millard. And distance is very negligible distance, 200 meters.
200 meters.
I beg your pardon. I have filed additional evidence flag B, where the RI has given the report of the land which is available. It was also
But
published.
now it is within 200 meters.
No, your lordship.
He's saying that it is the 200 meter.
Let's see page 3. Page 3, Millard.
200 meter from the border of the village Nota.
Then why are the public operating from a different place in a rented room, and it is in the place for Lalitpada?
Yes,
They are
they say it's a temporarily, it is temporarily running there, and it says that the moment the construction is complete, it will be fully operationalized.
So actually, the matter is that here in the village Nota, there are 5 other services.
File your affidavit. They state the name, submit. Stop the construction.
I have filed an IA.
Since the substantial writ also, there is no question of post-mortem after the judgment is passed.
Well, here in this village, there are already 5 public services which are going on.
Maybe it is within the policy decision of the government to take it.
But then
And the affidavit that the government filed, I have said, earlier I have said.
Your Lordship, the publication was for Notar village. Then why they have deviated from?
We have recorded, and then they have come up. If you want to read 2008, volume 11, SCC, page 1, paragraph 24, 25 of the judgment, please read that.
However, they are being affected. That is why they have come up with so much of pain.
We are guided by the law, not by the sentiments or the emotions. If the law fetters, then we can't do anything.
Until 17th March. Item 14. Item 14. There are 2 issues involved. So far as issue number 1 that has been reserved.
Just a minute, Mr.
Number
Behra,
1
minute. Mr. Behra, just a minute.
The vehicles having no.
Mr. Behra, just wait.
And Learned AG is appearing for the second issue.
But Learned AG is, I can see his mouth is really working, but his voice is not coming out. So what we do?
No, let me, there is something. Milord, now is it coming? Am I audible now?
Yes, you are audible. Yes, what you are the petitioner or what?
Yes. I'm filing a rejoinder.
What?
Issue is very simple. Let me just, Milord, brief your Lordship, Milord, address your Lordship on one issue. So far, Milord, the counter is already on record. It's very exhaustive.
Or voluminous. Exhaustive or voluminous?
Milord, I am unable to laugh today. I am having terrible cough. So, 4.2 is the only thing which is to be addressed to your Lordship of the last order. So, whether, Milord, the non-clearance of the pending challan is a condition precedent for issuance of the pollution under control certificate. That's the solitary issue, Milord, which I am supposed to address your Lordship. And the stand of the government
This was the denial of the sale of the petroleum products.
No, not
petroleum.
Petroleum we have already withdrawn. Petroleum, that is already.
Now, then what issue remains?
No, Milord, the circular which was issued earlier directing the petroleum companies to direct the retailers not to issue the petrol in the event of non-production of PUCC and challan, etc. That order has been rescinded. Your Lordship have dealt with in the previous order. That is no more the issue.
Then,
if I may request your Lordship to turn to para 4.
No, I understand. I understand.
So only
what remained?
What is the second issue?
Second issue, whether pendency of challan is a bar for getting pollution certificate. That was the issues. And your Lordship also consider keeping.
Just a minute, Mr. Behra, let me address. Wait.
You are assisting him. Okay. Your senior is addressing.
Mr. Acharya, I in fact sought for clarification from Mr. Prabhakar.
No, your Lordship may not. I am sorry.
Yes.
So actually, Milord, I am appearing.
No, I was.
No. But the judge can ask any clarification from any opinion.
My apologies, Milord. I didn't tell because Milord, this VC therefore is a problem. Today I am not well.
Who is appearing for anybody? 8 or something? There was a direction.
Sufficient.
Milord, 4.2, your Lordship may kindly turn to the last.
No, just let me first, technical part, let me. Service upon 3568.
8 months.
Have you done it?
I am for 6.
You are appearing for 6 and then 5. There was a direction upon you to serve.
That's already some.
they have filed affidavit.
Where is the affidavit? Have you served? Tell me, sir.
They don't have any role, Milan. This oil companies absolutely they don't have any role.
They
They
have
were only issued with a notice that is no more the.
Just 1 minute.
Mr. Acharya, Mr. Acharya,
Just 1 minute.
paragraph 3, they have in their affidavit. Last
पार्टी खुली होनी और मैसेज दे दो
It has already returned my letter.
Return
Address.
with the remark.
Remark no such person in the address.
Okay. Who is 8?
Indian cells. Sale India markets. Sale India markets.
Shell.
Shell.
Shell India.
Shell India markets.
They are the lubricants.
They are no more. Their presence is not. It is not.
Anyhow, we can ignore. We can ignore. Now the question is the Advocate General that how can it be if there is a pending challan? Can you refuse to issue a pollution control certificate or pollution clearance certificate?
Yes, I will, my lord. Yes, answer is yes. I will, my lord, address your lordship on that.
Please show us the relevant provisions.
Your lordship may let us go one by one. Now your lordship may kindly turn to page 35 of the bill. Before that, let me just tell the brief background of the rule, relevant rule. Your lordship would find it. Lord, let me, two things let me clarify. This road safety and environmental hazard are the two major concerns so far the plying of vehicles on the roads is concerned. But there are lots of judgments on the issue. MC Mehta, State of MP, and Justice Indira Banerjee judgment is the latest one. So far this PUC and non-registration is concerned. But I'll place the judgments little later. Let me first highlight the statutory provisions which govern the field. So far the grant of PUC is concerned and also, my lord, the challan is concerned. Your lordship may kindly turn to first rule 167 of the motor vehicle rule. For brevity, I have given it in the counter affidavit. Your lordship would find it at page 115.
What is this? Copy.
100 minutes, the rule I have given the relevant rules. 115 of the counter affidavit. Let the running page.
No. Rules are
rules, motor vehicle rules. Rules 1.
That is central.
Is Odisha or central?
Central
No,
model.
that is central rule.
Central rules.
Prompting.
168
million.
167.
No, he is referring to 128.
Page number 128, it's the amended rule, my lord. The relevant rule is 167. So therefore, I am directly this say, my lord, this rule was amended on 28th of January.
No, 157.
I think he's referring to 167. This is amended on 20th January 2026.
Right. My lord, Justice Raman is right. This entire rule 167 has been substituted.
167. So, but this is the
It
rule.
has been substituted, my lord, for the old rule.
2020, the amendment has come.
20th of January, my lord, last month.
Oh.
26, my lord. Only a fortnight ago. That is after the filing of the writ petition.
Do you have
No, 26 just now. There cannot be any book.
No,
You have the copy of that amendment.
I have given it in the counter affidavit, my lord.
You have given it. It is not it's a PIL, what counter? There is no counter concept in the PIL.
My lord, can it be?
It is affidavit.
The other side,
which page?
page 128.
28.
This is the new rule for the old 167. That
Yes.
has been substituted. This is the present rule.
Yes.
That is, the procedure for issuance and payment of challan. So therefore, I was
Yes.
Your Lordship, that what is the provision with regard to challan and what is the statutory provision governing the field of PUCC.
Yes.
These provisions are important and how they are correlated. Any police officer in uniform or any other officer authorized by the state government in this behalf shall issue a challan through system, either in physical or electronic form, to a person acting in violation of the provisions of the Act or the rules made thereunder. Notwithstanding anything contained in Sub-Rule 1, in case any person who violates the provisions of the Act or rules made thereunder, the state government can enable auto-generation of challan through electronic monitoring and enforcement system or manually by any police officer or any other officer authorized by the state government. The challan issued under Sub-Rule 1 or 2 shall be delivered to two ways. Either the transport department is doing it through electronically, through the mobile vans, interceptors, and the CCTVs installed on the roads for ensuring road safety. So to check the rash and negligent driving on the road, which essentially endanger public safety, causing loss of human lives, shall be delivered to a person who violates the provisions of the Act or the rules made thereunder, either by hand or any other physical means, within a period of 15 days, or by electronic means of communication authorized by the central government or state government within a period of 3 days. Details of challenge issued under Sub-Rules 1 or 2 shall be recorded chronologically on the portal. There is a Bahan portal which is maintained by the IT of central government. I'll come to that little later. Any person to whom a challan is issued under Sub-Rule 1 or 2 shall, within a period of 45 days from the date of such issuance, either accept and pay the amount specified in the challan or contest the challan on the portal along with documentary evidence in such manner and before such authority for redressal as may be specified by the state government. So here, the power has been given to the state government to specify the manner in which an aggrieved party against whom a challan has been issued either under Schedule 1 or 2 to contest it, that no, this is not due. So you have unauthorizedly or illegally erased the challan. So natural justice is complied. Where a person does not contest the challan before the authority referred to in Sub-Rule 5, the challan shall be deemed to have been accepted by such person on the expiry of a period of 45 days from the date of issuance of such challan. So there is a deemed acceptance if in the absence of any challenge to the amount so raised either electronically or manually. The challan deemed to have been accepted under Sub-Rule 6 shall be paid in physical or electronic form within the next 30 days from the expiry of the period specified under Sub-Rule 6. Where a person contested challan before the authority referred to in Sub-Rule 5 and is not resolved by that authority within a period of next 30 days from the expiry of the period specified under Sub-Rule 5, or where such authority, after hearing this submission and documentary evidence made by the person against whom the challan has been issued, quashes the challan for reasons to be recorded in writing, such challan shall cease to have effect and upload order on the portal. Similarly, there is also hearing process, etc. It can also be waived. Where the authority referred to in Sub-Rule 5 rejects submissions made by any person against whom the challan has been issued with reasons to be recorded in writing, the person may either pay the said challan within the period of 30 days from the receipt of uploading of such an order on the portal, or may file an application before a court after depositing 50% of the amount specified in the challan in the appeal as may be specified. So there is also appeal against that, the rejection order. If the person referred to has neither paid the said challan, this is important, my lord, has neither paid the said challan nor contested the challan before the court within 30 days from the date of receipt or uploading of the order on the portal, the challan shall be deemed to have been accepted and the amount mentioned in the challan shall be paid either in physical or electronic form within the next 15 days from the expiry of the period specified herein above. The notice shall be sent through electronic means every day from the expiry of the period specified in sub-rule 7 and sub-rule 10. It is being transmitted because the registered mobile number is there. So, my lord, this is important. This is the old rule 7, rule 12. Well, this is if no action is taken by the person to whom the challan is issued under sub-rule 7 and 10, in such cases, till disposal of such challans, applications with respect to the license of offender means the driving license, or registration of motor vehicle, as the case may be, mentioned in the challan shall not be processed by the licensing authority or registering authority as the case may be, except applications relating to any tax, issues of motor vehicle, except these two things shall be dealt with. Tax is not the issue. Earlier it was permit and another thing, permit and fitness. So that has been also omitted. And such vehicle shall be flagged as not to be transacted. This was not there. What is not to be transacted? That your lordship would gather from this central government notification. Shall be flagged as, this is not to be transacted on the portal, which shall also automatically send an intimation to the registered owner or the license holder, as the case may be, including through electronic means, till the payment of such challan on the portal. What is not to be transacted, your lordship would find it at page 35. Lordship may kindly turn to Abdul Gain 35. 33, my lord. Annexure C/2. This is central government, just a minute. This is central government. Address to all Director General of Police, Principal Secretaries of the State's Transport Department and Transport Commissioners of all states and union territories. As you are aware, may I read? The Bahan portal plays a key role in the implementation and enforcement of Motor Vehicle Act 1988 and the Central Motor Vehicle Rules 1989 across the country. Presently, blacklisting of vehicle is carried out on Bahan as per the request received from states, union territories to restrict further transactions till such time as the reason for default is suitably addressed. Multiple representations received by this ministry from vehicle owners, transporters, etc. have highlighted cases of wrongful, erroneous blacklisting of their vehicles, thereby causing much distress. That has also been addressed. The central government is conscious of all those grievances. Therefore, based on a comprehensive review undertaken by the ministry, including consultations with multiple stakeholders, a new system for flagging of errant vehicles on Bahan has been finalized. The list of categories under which vehicles can be flagged on Bahan as not to be transacted, which expression now finds place in the amended rule of 20th January 2026, is appended as Annexure 1 and will be treated as per Rule 167 of the Central Motor Vehicle Rules 1989. Such flagging shall be carried out and removed only by the parent RTO, and other authorities would be permitted to send a request electronically to the parent RTO through the system. The new system shall be implemented with effect from 15/4/2023. Therefore, NIC is requested to make necessary modification in Bahan for implementation of the new system. Though this not to be transacted expression was not earlier present in the rule, so the lawmakers being conscious that this may face challenge because that was done in consonance with the Supreme Court directive in MC Mehta and State of MP. I'll place those two judgments before your lordship. There is a Supreme Court Transport Committee also headed by Justice Sapre. I'll come to that report also. So therefore, your lordship may now kindly turn to the next page. Please 35 Millard.
Yes.
List number 9. Categories of flagging of vehicles as not to be transacted on Vahan. The entire list, Millard, description, theft of vehicle, pending tax area, government decision, vehicle, we are concerned with list number 9. Others under this drop-down list, vehicle offered as surety guarantee against when concerned, where, Millard, the third, my Lord Justice Raman may kindly peruse the third one, where challan is pending beyond 90 days and on expiry of period 10 days from the date of issuance of notice served under Rule 167(6) of the Central Motor Vehicle Rule, Rule 167, reasons, these are the category of vehicles which are not to be treated as not to be transacted. Millard, once this portal, Millard, shows that this particular vehicle is blacklisted and flagged off, and Millard, the particular expression not to be transacted is shown, PUC cannot be issued, Millard. So therefore, the challan, now your lordship may kindly turn to Rule 115 of the Motor Vehicle Rule, which deals with, Millard, the PUC. 115 of the rules. I think it is not here in the brief. Millard, I may request my lords to see Rule 115. It's a very lengthy rule, both 115 and 16 of the rules. Millard, these two things your lordship is well aware. This motor vehicle concept, your lord, road safety, and Millard, which causes not less than the average, the maximum casualties on Indian roads are due to rash and negligent driving, and the maximum environmental hazard is being posed because of environmental pollution, emission of the pollutants from the spoiled vehicles. So Delhi situation, your lordship knows, therefore they restrict the vehicle. Now the diesel vehicles are being gradually withdrawn from the roads. So this ATS system, automatic testing substation stations are being installed all over the country to scrap those vehicles, so to take them off road. So therefore, this endanger to those who are posing serious threat to human lives. Both the things, Millard, rash driving.
Sir, only one thing is, and we have to give the meaning of the expression not to be transacted.
It is already there.
Where is the definition defined?
No,
it does not talk about
by the government. It says, Millard,
categories. These are the categories for flagging of the vehicle not to be transacted. Now, question is, these are the indices where it is not to be transacted. What is the meaning of the word not to be transacted cannot be deciphered from this page 33, 34 and 35. There is the incidences.
No, your lordship is correct. So I was
asking what is the
same question. I was trying
to one has to understand.
Millard, this Vahan portal, your lordship knows now everything have to be transacted.
So they cannot transact. Does it mean that what is the meaning of the word transaction?
Yes, your lordship may kindly turn to page 46 is the answer.
Please.
SOP, Millard, which has been issued by the Government of India, Ministry of Roadways and Safety,
yes,
Road, Transport and Highways,
for
implementation of Section 136 of the Motor Vehicle Act and the Rule 167A.
Yes.
So that is the SOP, because that authorizes page 66 of the brief.
Yes, sir.
This SOP, Millard,
yes.
This SOP issued by the Government of India. Millard,
yes.
Incidentally, Millard.
No, 66.
No,
which clause?
1 minute. That is a prayer. Incidentally, this is Central Act, and the state government has taken action in conformity with all the circulars, guidelines, SOPs, and etc. framed by the central government. Union government is a necessary party to be heard in the matter, because whatever is being done by us, it is not on our own. We are following, adhering to the directions issued by the government of India, because road safety finds place in the union list, in the concurrent list, in the state list. That it is such a subject, ironically, which, my lord, is covered in all the three lists. My lord, entry, just a minute. Entry, your lordship may kindly turn to the...
I understand. Suppose if it is in a concurrent list.
Yes.
And if
anything which we have been
promulgated, if the act is promulgated by the central government.
That's correct. No, not
which will prevail.
All the guidelines are also issued by the Supreme Court of India and the central government. We have not devised anything on our own.
Let us see. Let us see.
Is not our this not be transacted is not our circular.
No, I understand. We are really our endeavor is to find a suitable meaning
in
of
that
the word
event,
not to be transacted.
In that
is what I wanted to know from you.
In that event, your lordship should hear the central government. But, my lord, this not to be transacted is not our terminology. It is a terminology.
No, what is what you perceived about not to be transacted? It is once the document of the central government comes. Yes. And you being a
I'm so grateful. That is right. I'm so grateful.
State,
so that document is that document.
How you have treated it and how you have interpreted this word not to be transacted. Anyway, in your
yes, your lordship may kindly turn to now. This answer is to be found out from page 131 of your lordship's query. 131.
31. Okay.
Yes. Clarification regarding treatment of PUC testing as a transaction under Rule 167(7) of the CMBR 1989. This is 27th January 2026 clarification. Just not a weeks ago, this was issued.
Yes, please.
So because this not to be transacted concept was introduced in the statute, in the rule, only on 28th of January. On 27th January 2026, this clarification has been issued by the Government of India. Because there is your lordship knows in every rule, there is in case of an ambiguity, the competent authority making the rule can issue the necessary clarification. I am directed to refer to your letter. This is with response to our query to the Transport Commissioner cum Chairman, State STA. Dated 8/1/2026 on the above mentioned subject, seeking clarification on whether pollution under control testing and issuance of PUC certificate fall within the scope of term transaction.
Mr. Advocate General, this is what really we wanted. This is what we really wanted. This kind of. Now the clarification has come.
Yes,
the clarification has come. I understand.
Unless a question comes, my lord, in my yes, so
no, I got your point.
Putting the right question, so the answer is there. It is a very
yes, I got you. I got you
with every aspect.
I got you. There is no difficulty.
Those questions will come from the court. So,
no, I think there is no further deliberation to be required on the basis of this.
Incidentally, the order of your lordship is dated 27th of January. No, yes. Incidentally, the order of your lordship is of 27th January. That petrol issue. Lordship wanted a clarification on the second issue, whether it is a condition precedent for grant of PUC.
True.
On the same day,
this
clarification has come from the government.
Yes, that's true.
So the answer is gone. So
no, that's true. I understand. That's why I say yes. What do you say? After this is there.
Yes.
And this is a part of the statute.
Yes.
If the statute prohibits that no pollution control certificate can be issued if there is a pending challan, then in that event you can't flag an issue that they cannot be done.
Correct.
That comes under section, Rule 167(7). They have issued it.
It is not available. Singer is not available.
No. It's a
very was giving praise by.
Pray for day after tomorrow.
No, nothing.
Despite my illness,
I will file a rejoinder.
What is this is a pure question of law. They have come, you can't deny this particular document. This document is there on the face of it. And it is of a recent origin. On the last day, when on 27, this issue was flagged, 167 was placed before us. Then we say that how can it come not to be transacted? In a common sense, transaction means when there is a sale and the purchase of the vehicle. That is what in a commercial parlance it is known as a transaction. When a goods passes from one hand to another, and POC is not a goods passing from one hand to another. So that was a confusion which was there. Now this same day the notification has come. There the central government has, which is competent to clarify it. They say the transaction means any kind of a transaction related to a vehicle which has the pending challan, which are required to be uploaded on the portal. Purchase of the petrol and the diesel does not require any registration or recording in the record maintained by the transport department. No. So those are beyond the purview of that particular transactions or 167. But this POC, there should be a recording of every vehicle that it has been issued by a competent. And therefore, they have clarified that it comes within the word transaction. So once the clarification has come, that's what it is. It's nothing. No, nothing. There is nothing. This can be done. So that is one of the open and shut.
So what is the condition?
That is what the earlier issues.
Amendment has come on 20th January. To the entire one. Has been issued with regard to transactions.
The instant public interest litigation was
directed to the municipalities to file the affidavit whether any petition or any interim order is pending before the honorable signature. I have filed this in the affidavit in the lordship on 7th and your lordship may peruse that there is no petition is pending, no interim order is still pending, and I have annexed as paragraph 5 of the affidavit, your lordship. I have
Where is the affidavit?
Flat.
Flat 10.
Flat 10.
Yes. No, a review application is pending.
Well, in the review, I am the decision.
With instruction.
No, I'll assist you also. Let them come.
That the writ petitions arising such and such were dismissed and disposed of, so there is no case pending. That review number arising from such and such is pending before this honorable court. Although the review petitioners were not made parties in WC such and such, since no case is pending in the single case.
And I have annexed also copy of the order of the
So review is also pending before this court.
review is only pending.
So what is the review
Yes.
petition? Give me a review petition.
Yes.
I have filed a petition for intervention. In review, I have filed a petition for intervention because I filed the first writ petition before the Sonor Court for eviction
Give me a
of
review petition.
encroachers from the road minor and in front of my house.
What is the order which you sought to review?
Yes. My lord's order is under Annexure 1.
Sure.
9/12/2025. 9/12/2025 orders in the WPC number 16778/25.
Yes, what?
My lord, before taking the order which I am going to place as before your lordship, my lord, kindly see my lord's order dated 24/12/2025. In that, my lord, after hearing me, passed an interim order. Why your lordship passed an interim order? It is as per this month.
24/12.
Yes, sir.
No. That was passed at that point of time. The impression was given that your writ petition is pending and you are protected with the.
Yes.
Now they say that subsequently your writ petition is dismissed, interim order has gone. So what?
My lord, why?
Tell us.
My lord,
So don't go by this 24/12.
no, I am not on this.
Still, we have not gone deep into the matter to find out whether on 24/12/2012,
Yes.
whether your writ petition was pending or was already disposed of.
That way, my lord.
We are not going into deep. If we find that it was disposed of earlier, then your conduct would be one of the thing which the court will definitely view seriously.
On the date your lordship protected me on 24th of December 2025, if my writ petitions were dismissed, whatever punishment your lordship awards, I will accept it gracefully.
So we are not going into that. Treating that as on that day it was pending. Now subsequently it has been dismissed, disposed of. Now what remained?
Municipality.
Yes.
On conduct of the municipality.
What is the review? Then why review?
Review was when your lordship passed the order under Annexure 1, it was not brought to your lordship's time consideration that we are already enjoying an interim order by the Honorable Single Judge.
That is a different issue.
It was not brought to your lordship.
Whatever be that this cannot be. Now the situation is that during the pendency, your writ petition has gone, your interim order gone. What more?
My lord, in the review, I just want to draw your lordship's kind consideration that the conduct by the state as well as the municipality was not above the board. If your lordship sees it,
Then what is the parameter of review, sir?
so my lord, on the date of review, there was an interim order, and in spite of that order, they demolished, my lord, 16 shop rooms out of 74 shop rooms. In spite, there is an order of stay.
In respect of 16.
16. They demolished. When your lordship's order was passed and I could get the certified copy, they stopped the demolition. Though I brought to their knowledge that the review is being heard by your lordships on that day, that morning I brought to their lordship notice, and your lordship might recollect. From morning thrice I mentioned, and my lords were kind enough to take me because that was the last working day. Your lordship took up, and the moment your lordship passed an interim order of file, I moved the authorities that, sir, Honorable Court has granted me an order of stay. They still did not wait. They demolished 16 shop rooms. And this conduct, my lord, if municipality should not be taken to task, then, my lord, I am nowhere.
No, then one thing is that you are invoking a particular jurisdiction. Will the review jurisdiction meant for these purposes?
My lord,
I am asking this question. That may be, I know, appropriate forum. Maybe you may be explored. But whether the review is the appropriate forum.
My lord, why I brought the review is two reasons, man. First, there was material suppression before your lordship, which none of this, neither the state nor the
Does it invite or come within the purview of review?
My lord, on seeing that your lordship granted me interim protection. Yes, it is absolutely correct.
So
what
then what is the course of
interim protection? I am not covered by any interim protection. Admitted, and when your lordship passed the order under Annexure 1, that time I was protected.
Prior to that.
May kindly turn to Annexure 1, Para 7.
Sir, I am on the scope of review.
Yes.
You satisfy me that this comes within the purview of review? No difficulty.
But why it comes within the scope of review, subject to what your lordships decided? That the orders which were passed by the Honorable Single Judge and the orders were reserved on 17/11, it was heard on 17/11/25. The orders were reserved on 9/1/26. Against me. So my yes.
It's not against me. It was a general, the public interest litigation.
No. My lord, I am talking about myself. I am concerned with the Honorable Single Judge.
What is, if there is something, I think if your order is passed in ignorance of certain facts or gross.
My lord, it was not placed before your lordship. No, it did.
What should be or the actual remedy?
My lord, if a party is not in litigating with me before the Honorable Single Judge, he could not have placed that as an order. These parties were litigating with me before the Honorable Single Judge. And when this was done at their, it was in their presence this order was passed, they could have brought to your lordship's kind consideration that such an order is there staring at them, which they did.
I am for the petition. I am for the petition.
It is petitioner in the PIL.
Hello, now I am placing my one judgment of the appeals court. I am placing what is the intention of the judiciary, Supreme Court, my lord.
First intention of the judiciary is the litigant must come before it with a clean hands. If the litigant is guilty of a gross suppression of the fact, it is not only tantamounting to a fraud on the court, it is a fraud on the system.
My lord, in this case, my sole prayer is, my lord.
Your sole prayer is when you know that there has been a litigation which is beautiful. You knew it everything, but you not before the court, you not bring all these facts before the court.
He's not a review because the order of the appeals court has not
You
been.
were a party there in that relation. Are you not?
No, no, my Surjakant Sahu was not the party.
Then
Municipality was the party.
municipality did not, but did you not?
No, my lord, I also make a party in that case, my lord. I have filed the case for 16278/2025 as a PIL, my lord. I don't have the knowledge of that case and if there any interim order governing in the field.
My lord, no, my lord, your lordship, see, there is the order dated 19/6/2025 in that writ petition. And on that date, I had submitted before lordship the two cases are pending before the honorable single judge, and I have also your lordship directed to only to seek what is the order and regarding this writ petitions. And on that day, on that disposal date, on the date of disposal, your lordship 19/12/2025, and your lordship reflected that is paragraph 5(1), the writ petitions were disposed of and also not pending. But on that day, my lordship, see, that is 5.
There was one writ petition pending, which was
And another, they have filed another, other writ petitions, my lord. But these your lordship, see, that is 19/6/2025, your lordship, see, bona fidely, and so I am not suppressed anything I have stated. Your lordship, see, that in the government road.
You are this matter tomorrow. Let me satisfy this.
I will take that judgment for your
tomorrow.
Then item 51 will be taken up tomorrow. Yes, sir. Item 51.
Item 50. Item 50 maybe tomorrow. Just order. Item 50 minutes.